Hey, I want to thank everybody for tuning in today. Folks, we recorded this episode just before James Comey's indictment was thrown out by the court. We don't think the story is over yet because the Trump administration is already saying they're going to try to find some other way to indict him again because their persecution program cannot proceed without Jim Comey being one of their chief targets. Delighted to have Andrew Weissmann on the show today. He is so smart about the legal backstory here. And even though this case has now been dismissed, I think you'll find a lot of value in Andrew's tremendous wisdom about how DOJ does now operate and should. Thanks, folks. See you soon.
Your task will not be an easy one. Your enemy is well-trained, well-equipped, and battle-hardened.
There is not a liberal America and a conservative America. There is the United States of America.
Good night and good luck.
Hey, folks. Welcome back to the Lincoln Project Podcast. I'm your host, as always, Rick Wilson. I'm delighted to be joined today by the brilliant legal mind of Andrew Weissmann. We are going to talk through the abuse of power that is happening in Washington at a greater scale and a faster tempo than I think any of us could have possibly imagined in a system where the rule of law meant something. So, Andrew, thank you for coming on today, my friend. I appreciate it. I
Well, Rick, what are we going to talk about?
I don't know. There's
mean,
just so few things. I mean, the Supreme Court in the tariff discussions last week came across as more united amongst each other and more skeptical than anything I've ever seen. So I think we'll start there. Then I want to jump to the Keystone Cops persecution of Trump's enemies. Donald Trump has used this emergency declaration to seize a congressional power, which is to set taxes and tariffs. Were you shocked by how the court seemed? This seemed to be the most unified they'd ever been on any issue that I've heard in the last couple of years.
Well, let's remember that with the Abrego Garcia case, they did actually say twice, 9-0, that due process was violated.
The man mistakenly deported to El Salvador is now getting help from the Supreme Court. The justices said the Trump administration must facilitate the return of Kilmar Abrego Garcia. He had a court-ordered protective status preventing his removal. In a court filing, the government admitted it mistakenly deported him due to an administrative error. Sonia Sotomayor wrote, quote, "To this day, the government has cited no basis in law for Abrego Garcia's warrantless arrest, his removal to El Salvador, or his confinement in a Salvadorian prison, nor could it."
That is pretty remarkable when you think about it. That means Alito,
Right.
and Thomas, and Gorsuch,
Yeah.
and Kavanaugh, who are sort of four votes that pretty much they stand together.
Yeah.
But then, that sort of, you have to remember, that was sort of the beginning. And then there's been a slew of things that where you're absolutely right, it's just very, very divided. I was surprised, but because, there's this shamelessness to some of what they do where you're just thinking, oh, well, that's totally inconsistent with originalism.
Right.
And that seems to be like, it's like, it's like talking to the air. I mean, they just are like, who cares? We're still going to do it. And Justice Alito has a way of just being like, it's originalism until it's not convenient for me. So I was surprised at Justice Gorsuch being seemingly very much focused on congressional power. And this was, remember, this is all about a congressional statute. We're not talking about sort of the president in his sort of, Article 1 versus Article 2 power. We're dealing with something that is congressional power. And the only reason the president gets to act is because of a statute. That's one of the reasons why when at some point of the argument, just to be a nerd, they were like, but are you saying that the president couldn't do this? And it's like, what are you talking about? The president can go to Congress and ask them.
Sure.
When you're dealing with a congressional power, that is the way it works.
It's black letter congressional power. There's no disputation about, and that was what sort of stunned me is they've had this incredibly expansive view of executive power. And there seemed to be a little crack of daylight there on some skepticism about the nature of the emergency. And I think they called the Solicitor General's BS a little bit on him trying to say that this wasn't a tax.
Yes, absolutely. And they sort of press that a lot. Say,
Yeah.
walk me through how
Yeah,
that
help me
works. It's like,
understand.
Let me ask you about the premise of your argument, which you sort of started at the beginning saying that one would expect for Congress to give the president a broad leeway in this kind of foreign affairs context. And I guess I'm wondering whether you also don't have to contend with the actual purpose of IEPA in making this argument, because as I understand it, that the IEPA was designed and intended to limit presidential authority, that Congress was concerned about how presidents had been using the authority under the predecessor statute, TWIA, and it's pretty clear that Congress was trying to constrain the emergency powers of the president in IEPA. So it seems a little inconsistent to say that we have to interpret a statute that was designed to constrain presidential authority, consistent with an understanding that Congress wanted the president to have essentially unlimited authority.
I disagree with that, because what Congress actually did
What part do you disagree with? I'm sorry.
Well, I disagree with the notion that they were trying to constrain the breadth of the actions the president may take when it comes to this particularly narrow domain, which is, various regulations of transactions.
But how can you disagree with that? I mean, the history is what it is.
Because they made a series of changes to IEPA that relate to the triggering conditions, so to speak, and the procedures that apply, but they did not change the language in IEPA.
Right, but what was the intent of Congress in changing the language? Wasn't it to constrain presidential authority in this area?
To constrain it in the triggering conditions and the procedures that apply in this
those are the triggering context. The triggering conditions and procedures that apply are a means to constrain. That is how they went around about constraining. But my point is that Congress enacted this legislation with the intent of preventing the president from having unlimited powers in this area, and you're asking us to now interpret that statute consistent with an understanding that Congress wanted to allow the president to do pretty much whatever he wanted in this area.
and there was sort of this, there was a sense of like, you know what, we're not going to blink at reality. So that was fine, but we'll see where they go. I mean, there are two things that are up there now that are interesting. The SNAP case, which may become mooted out, but that's one where, I'm going to actually take the Rick Wilson view of the world here, because I view that case not so much as, I'm a legal analyst, but that's one where it's very hard for me to put my legal hat on and be like, the administration has decided as a policy matter that they're not going to feed people.
Right.
And the statistics are astounding.
Mortifying.
1 out of 8 Americans get benefits. What does it say about a country that thinks of itself as the richest country in the world, that 1 out of 8 of us needs to have food assistance? That's the problem. And that's the thing that needs to be fought. This is where you actually are thinking you need President Johnson back in terms of the war on poverty.
Yeah, and as heartless as I think some people believe this court to be, I do also think there is a sensitivity to the capriciousness of the cruelty on this case, on the SNAP case. And I've always, I've watched the court Lucy with the football for 11 months like everybody else has. Wondering when they're going to say, why, yes, there is a boundary to presidential power. Why, yes, there is an upper limit to presidential power. That would seem to be one that would send a real message. I also think this week they sent a message by declining to take up the gay marriage case.
The Supreme Court has declined to revisit its landmark 2015 ruling that legalized same-sex marriage nationwide, leaving the decade-old decision intact. The High Court on November 10th rejected an appeal from former Kentucky County Clerk Kim Davis, who drew international attention for refusing to issue marriage licenses to same-sex couples. Davis had asked the court to overturn Obergefell versus Hodges, arguing that her religious beliefs should protect her from paying damages to couples she denied licenses after the 2015 ruling. As per CNN, lower courts had previously ordered her to pay more than $360,000 in damages and legal fees. the Supreme Court declined to hear her appeal without explanation, a decision that offered reassurance to LGBTQ plus advocates who feared that the court's conservative majority might reconsider the landmark ruling. As USA Today notes, the justice's refusal to take up the case leaves Obergefell untouched, safeguarding the nationwide right to same-sex marriage that millions of Americans rely on to legally recognize their families.
And I'm wondering about your take on that, because this was something the court, decided just recently in court timeframes. And I'm curious why you think they declined this particular case.
So I am very, very cynical on these issues about what they take and what they don't
Right.
take. Now, it is true they are going to have their fill of controversial cases. But, this reminds me of they kicked the can down the road on mifepristone
Sure.
before the presidential election. And, that just seemed like a very political decision to me. And that was like, we're going to give you bad news, but we're gonna do it at a time where it's gonna have not have those political ramifications. Remember, Justice Thomas has basically said that he doesn't believe in substantive due process, and he's given up the ghost on all of these rights, saying that this all needs to be rolled back. And obviously Dobbs was, everyone knows where the court went with that, but it's like that the issue is whether that's step one.
The 14th Amendment says that no state can deprive a person of life, liberty, or property without due process of the law. Now, a constitutional expert told me there are two strands of thought when it comes to this amendment. The first, that it guarantees the right to liberty, period. The second, where Thomas resides, is that it only guarantees due process before that right is taken away. Justice Clarence Thomas wrote a concurring opinion.
A concurrence is when a justice writes separately because he has something separate to say. And so Justice Thomas wrote separately and said, I'll go along with this decision, but I would go further.
Thomas argued the due process clause under the 14th Amendment does not secure a right to an abortion or any other substantive rights, and said the Supreme Court should apply that reasoning to other landmark cases, like the one that allowed for same-sex marriage or the right to contraception. The rights under the 14th Amendment go beyond that, though.
The right to rear your children, to choose where they go to school, the right to not be sterilized.
McGeorge School of Law professor Leslie Gilo Jacobs wants to make it clear.
No one else joined Justice Thomas's concurrence. And in order to have a change in the law happen, we have to count to 5 because that's a majority.
But that doesn't mean other justices won't join him if the right case arises.
It's very interesting to me that is the one part of Project 2025 that has not yet been overtly implemented.
Right.
There are lots of ways in which, and my friends who are in this space say, Andrew, don't let them fool you. There's lots going on, but they haven't taken a direct sort of court action to say that we really want to roll back as much as we can in the way that Project 2025 did. For instance, making it illegal to send certain things through the mails,
Right.
to prosecute people for that. Now there are sort of rumblings and there is things in the work, but this is a long way of saying that I'm very, very cynical about they're not taking the gay marriage case as like, oh, this is one liberal court that decision is, set in stone. I think that everything with this particular Supreme Court is on the table, and
Right.
people cannot be taking
You can't take your eye
that.
off the ball.
The fact that they didn't take it now, people should not be. Yes, it is not being attacked right now, but that is like, do not take that as that. To use your Lucian football analogy, it's like, don't be fooled.
Right.
Don't try and kick the ball again.
So I want to talk a little bit about this sort of ham-fisted approach that Trump has taken to the persecution of his political enemies. And while the Department of Justice is a terrifying edifice, where the minute the phone rings with the Department of Justice, your only other call is to your attorney. Um, but Lindsey Halligan so far has turned out to be an enormous clown show in going after Trump's political enemies. And down in Miami, it appears to be a similarly building clown show of sort of trying to prosecutor shop to find people who will go after Trump's enemies. Um,
And judge shop.
and judge shop, yes,
Right.
yes,
Because let's remember that the bringing something in Florida, where you're going, okay, let me just understand. You're opening a case on John Brennan for either something he said when he testified in Congress,
Right.
which would mean DC,
DC,
not Florida,
and
or something
DC
that
where
he
the alleged action took place.
right, exactly, or it's something he did while he was head of the CIA,
Right.
which guess what is Langley.
Yeah.
That's again, it's up, up north, and so I've made this comment, which is I was reading the Carol Leonnig and Aaron Davis book where they talk about Jack Smith deciding with some people in his team being very against it, saying we're going to bring the Mar-a-Lago case. Yeah, in Mar-a-Lago, we're bringing it in Florida because that's where the crime happened. We're not going to play games. We're not going to try and squeeze this into DC. And compare that, the person who is supposedly sort of weaponizing and accused of all these sort of being overly aggressive, is bringing the case where it should be. And I agree with him, and it should be there. I've been on high profile matters where I worked on Enron a million years ago, and it was going to be brought in Enron. I worked on the Mueller investigation. It was going to be brought in DC. Those are where things happened. And compare that to really, you're going to start looking at John Brennan before Judge Cannon, because there's so much that John Brennan did in Fort Pierce.
Right, right, in Fort Pierce, Florida. But that idea of Trump has clearly, he sent his what was supposed to be a DM on Truth Social to Pam Bondi, and suddenly all things start to roll.
Yeah. Well, it's overt. I mean, this is one where
Right.
there's not a lot of guesswork. This is something that James Comey has said in his motion for selective and vindictive prosecution. He's like, this is not one where you have to sort of piece together the data points. It's like it's in black
Here
and
it
white.
is. This is what he
Right.
said. In the Comey case, I mean, Halligan has been a train wreck on that. From even a non-lawyer like me can read between the lines here. She has no experience in as a prosecutor. She has no experience in even the filings seem to be messed up. Do you think that if this case falls apart, does the judge have the power to just say, this is selective prosecution, get the fuck out?
So the answer to that is yes.
Mhm.
Let me tell you two things that I am watching for, in addition to the selective vindictive prosecution and whether Halligan was improperly appointed. The two things that I'm watching for are that we, I think, are going to learn what she actually said to the grand jurors.
In an extraordinary concession in court yesterday, prosecutors in the federal case against former FBI Director James Comey admitted the final indictment against him was never presented to the full grand jury. Interim U.S. Attorney Lindsey Halligan, who has no prior prosecutorial experience, initially presented a 3-count indictment, but the jury rejected one of those counts, Justice Department lawyers said yesterday. Then, rather than drafting and presenting a new 2-count indictment, Halligan printed a new version without presenting it and admitted only the foreperson and another grand juror were present for signing it. The judge appeared skeptical of the government's arguments throughout this hearing and went on to question prosecutors on whether the indictment was retaliation by President Trump. The judge also questioned Halligan herself, calling her a possible puppet for the president. Comey's attorney went on to argue the judge should throw out the case entirely, saying Trump used DOJ to, quote, punish a perceived political enemy.
As somebody who was a prosecutor for 20 years, you do not go into the grand jury for the first time without a senior person next to you who has trained you about what you can say and what you cannot say.
Right.
And the reporting is that she went in alone, and she's an insurance lawyer. It is almost inconceivable to me that she didn't say something improper. Let me give you an example. there's a very defined window that is charged with respect to what Comey did or didn't do in terms of time frame. And if you look at the government's brief, they talk about all sorts of things that happened before the critical time period and after the critical time period, but almost nothing during the actual time period of the alleged false statement. And I am really curious what Lindsay Halligan told the grand jurors with what they could consider and what they couldn't consider. So I think there's a real issue about what the grand jury actually voted on, which could also tank the case. And the second issue, which was flagged in some of the pretrial hearings, is whether the government here has bathed itself and exposed itself to what's called attorney-client privilege. In other words, that they read and accessed emails and other texts and documents between James Comey and his lawyers. That is
Oh,
not just a no-no. That is, you can't dial that back. And there, one of the ways you deal with that, which I dealt with all the time as
right.
a prosecutor, is that before you look at something, you have what's called a taint team.
Right.
And so when we did the Paul Manafort search,
Mhm.
court-ordered search, the team that did that was a taint team. They were not on the Mueller investigation. They reviewed the documents. They met with the defense counsel. They sanitized everything that we could see and could not see so that we wouldn't violate his attorney-client privilege and we would protect our investigation. By uh, it appears by all accounts so far that none of that happened here.
My God. So I guess my question would be, why hasn't the judge already said this is so sweepingly inappropriate and so much impropriety exists in this persecution that you get out? I mean, I just wonder, like,
Great question.
is there a
So,
timing? Is there a
yeah,
timing question
so
here? Or
so great question because well, this from the all the Trump cases, which is welcome to the law, which is where it's not fast.
right?
And
Yes.
so other than as we're marked by, I think it's Ketanji. No, is it Ketanji Brown Jackson or Sotomayor who said that the administration seems to have the Supreme Court on speed dial? But
Right.
other than that, the the motion that James Comey made is now fully briefed, but it takes a while. He was
Mhm.
given time to put in his papers, the government put in its response, and then the reply brief was just submitted, I believe, yesterday. I read it. It's terrific. But now it's fully briefed. So now the judge has all of the papers from both sides, and he can make a ruling. My suspicion is that he is going to say that James Comey has met the threshold to get discovery on what this issue is.
Mhm.
It protects the judge from an appeal because it says, let's get more evidence, but it
Ah,
also puts the government in a really hard position because the discovery is essentially, tell me all of the communications with the White House pressuring you to do this. Tell me all of the internal documentation in the Eastern District of Virginia of career people and even the former U.S. attorney, a Trump appointee, who was pressured
right.
and said,
He
no,
said
I'm
no.
not going forward. So that kind of discovery could be incredibly embarrassing to the government here, and it could help bolster the James Comey case. And I suspect that that issue, if there is discovery ordered, that is an issue that you're going to see a lot of fighting over
Wow.
what gets turned over and what does not.
It strikes me that Halligan, I saw a little bit of reporting on this, that Halligan, that even Bondi has not been read on some of the stuff that Halligan has been doing, which I find really shocking, but not shocking at the end of the day. I mean, is she reporting directly to the White House?
Doesn't it tell you, to me, what I found interesting about that is the idea that somebody wanted to leak that out. In other words, it's like that to me. I mean, this is conjecture on my part. It read like somebody in Pam Bondi's office, if not Pam Bondi herself, going, Don't tag me with that stuff. Like,
Right.
I did not know that. So like whatever's happening there, it's not on me.
That really struck me, Andrew, because I know who Bondi's people are. I've known Bondi for 25 years from Florida stuff. She's not a genius, but she has a self-preservation instinct that is pretty strongly developed, and I think they managed to pass even a level where she can't meekly sit back and go, "I'm gonna get disbarred later for this. No, thank you." Um, because it really did that really to me was a very interesting internal fissure you saw. And you and I have talked about the DOJ before and how its sort of character is being warped at the top. There must still be a line attorneys, line prosecutors inside that building who are not gonna put themselves into this morally and legally compromised position.
Well, I want to just stick up for a moment for the Eastern District of Virginia
Yes.
career people.
Mhm.
Um, I know some people are like, "Oh, gee, why are they not all quitting?" They have voted here. Like, if we're not hearing what they're saying, it's because we're not paying attention. There is no Eastern District of Virginia person on this case.
Right.
They had to get two people from a
Didn't
different
they get a guy
office
from
to do the
Tennessee or
case.
something to join the
From
case?
I think it's North
Or North
Carolina or
Carolina.
something.
Okay,
But
close
yes,
enough.
so as a New Yorker, I was going to say same difference, but it's not because I've learned not to do that, although not entirely. So the Eastern District of Virginia, those are examples of people who are saying, "I'm not doing it. I'm not. I took an oath of office,"
Mhm,
and
mhm.
that, by the way, I do think it is important and worth contrasting that with the John Bolton case because in the John Bolton case, career people signed that. Career people both in Maryland and at Main Justice in Washington signed off of that. It doesn't mean it's meritorious. These are just allegations, but career people were willing to put their name on it. That is not true with respect to the Comey indictment.
Yeah, that strikes me, I mean, the Bolton case and, long history with John, but the Bolton case really did seem to be possibly tied into more actual, potentially criminal activity in the handling of classified than anybody else who's been sort of visible so far in this equation.
Yeah, look, you could read that indictment, and it was a detailed indictment, and you could understand, if proved, exactly why this case was brought, and you understood that other people who had done something similar had been charged. With the Comey case and Letitia James case, you really understood why the sitting U.S. attorney appointed by Donald Trump himself was like, no mas,
Like,
I am
pass.
not doing this.
Right.
Hard pass.
One of the cases that I or one of the issues I find fascinating here is, Trump obviously has told Pam Bondi, told the DOJ, and told these new people that are coming in from God knows where to serve in these cases, I want this done. This is my will. You will carry it out. What legal risks are these people putting themselves in by continuing to comply with Trump's orders here?
That's a great question. I think that the most obvious one, if they were to do something that was against the law or there was no factual support, just has to do with their bar ticket, whether they will suffer the consequences that Rudy Giuliani uh, and others, where they lose their license. I'm not saying that's going to happen, but that is a consequence that can happen, and we have seen it happen. Um, the issue, though, of whether they could face criminal liability is one where it's complicated because one of the effects of the immunity decision, the presidential immunity decision, that we have not yet seen play out is how much that's going to trickle down and spill over. The argument that's going to be
Oh.
made by underlings is, well, the president's immune, but he has to act through people. And so the people through whom he acts also are entitled to immunity, so long as they're acting within their official capacity.
Ah, That is, yeah, I could see that that is going to become another test of, does the president's executive authority, does it have an associative property to people down the line?
Exactly. I should say in the civil context, the Supreme Court has done that. It's watered down a little. It's not exactly as when you go down a level, it's not as strong an immunity. But the issue of whether that happens on the criminal side has not been resolved. And I would say, thank God that we have not been in that situation,
Right,
because
right.
until the Supreme Court ruled about presidential immunity, nobody in this country thought there was presidential immunity. We'd operated, except
Right,
maybe Richard Nixon.
that the
Nobody
world
thought that.
right, that the world had no anticipation of godlike powers in the presidency.
This will be referred to from now on as a landmark opinion of the Supreme Court. It's not only important for President Trump's criminal case, they really have set a framework for all future presidents. Donald Trump's defense team puts forward this argument that a former president should be held completely immune from prosecution for any of the acts that they performed while in office.
I feel that as a president, you have to have immunity. Very simple.
The court's very explicit about this. It lays out its framework by saying, quote, "The nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority." What the court is saying in this part is quite surprising. They're basically saying that nothing he does in terms of pressuring the Justice Department to investigate whoever he wants to investigate as president can ever be subject to criminal liability.
There's a longer list of other people that he's gonna go after, and that he's gonna send these other people after. I wonder if you think that if there's a sufficient volume of prosecutors he can find while he goes and shops for these, places that will bring these charges, and a sufficient number of line attorneys to carry these cases forward, or if it's gonna fall apart.
So, I don't think it'll be a question of, I think he'll find enough people. I don't know how much he'll find really qualified people. And, we can just look at what's happening with the James Comey case. And, I think that's going to be the canary in the coal mine. And, I think there's a really good chance that case is going to implode.
This is big. We have learned that the Justice Department's case against former FBI Director Jim Comey and the New York Attorney General have both been dismissed.
Well, they both are being dismissed, and for essentially the same reason that Lindsay Halligan, the Eastern District of Virginia interim U.S. attorney sent there by Donald Trump, not Senate confirmed, that she doesn't have the power. What the judge here has found, this is Judge Cameron Curry from South Carolina. She came into the district, heard arguments from both of the lawyers on these cases against Lindsay Halligan's role. They argued that she didn't have the power because she wasn't Senate confirmed, and thus these indictments are invalid. The judge is agreeing with that. Judge Curry is saying that the Attorney General's attempt to install Ms. Halligan as interim U.S. attorney for the Eastern District of Virginia was invalid. And because Ms. Halligan had no lawful authority to present the indictment, James Comey's motion is granted, the indictment is dismissed.
At that point, obviously, Donald Trump will say it's not my fault, it's the judge, it's, the jury, whatever. He'll blame somebody else for it. But, that's one where it reminds me of the executive orders with respect to the law firms. There were
Right.
4 of those issued. All 4 of them were struck down by a variety of judges, not activist judges. I mean, unless you think
Right.
like a judge appointed by Reagan and Bush are activist judges.
Those
And
woke Reagan judges.
exactly. I mean, I was listening to Todd Blanche at the Federal Society talk about these sort of a war on activist judges, and I kept on thinking, really, Karen Immergut in on the West Coast, she was appointed by Donald Trump.
Yeah, right.
Judge Wilkinson on the Fourth Circuit is one of the leading conservative voices in legal academia, and he was excoriating the administration about how they treated Abrego Garcia. So these aren't activist judges. These are so. I do think at some point we'll see whether they sort of get the message. I mean, obviously the midterms will really matter in terms of the administration understanding, does it have a mandate or not?
You know, about a month ago, somebody very close to the White House told me he loves to F with people, he loves to mess with people, he loves to cause, this chaos and disruption. These are good distractions for him. And this person said to me, but the one guy he truly hates in this process that he wants more than Comey even is Jack Smith. He feels like Jack Smith was his nemesis. And my theory of the case to this person was, I said, it's because Jack Smith got the closest to actually getting him on the classified documents case. If that had gone forward with a judge who wasn't obviously like looking up the chain, I think that case would have been, because, as a guy, you and I both have been around top secret stuff. And if you and I took top boxes of top secret documents home, we would go to prison and we would never leave.
We'd at least be prosecuted. I mean, I will say some senior people have gotten very lenient sentences,
Yes.
but if they pled guilty,
Sure.
but they've all been prosecuted. And so that was a very righteous case in terms of bringing it. I did an interview recently of Jack Smith in London,
Right.
and it turned out to be kind of
that
fortuitous.
was my next question, because you just had a conversation with Jack Smith. I'm curious where you see that inbound prosecution and his
So-
very firm position on it.
So here's one thing that I would so first of all, you do need to find something, right? I mean, like the James Comey thing is not much of something, but at least there was something to point to. So like so far, saying that you want someone to be prosecuted, like you do need some factual
Right.
predicate, even if it's wrong and trumped up. No pun intended. You need something. So, and Jack Smith is so squeaky clean. And he comes off like a Eagle Scout, and I think he is. And you can go to YouTube now and just because University College London posted the
Right.
interview, and he comes off like exactly what you would expect, which is like a career prosecutor.
Wired
And
tight.
again, exactly. And also, if you go to the reporting by Carol and
Yeah.
Adam in Injustice, over and over again, there are steps that are taken that are not sort of weaponized. The venue issue is a perfect example. He is bringing the case in Fort Pierce, right? He is bringing the case in Florida. He is not bringing the case in D.C., in spite of the fact a senior person on his team is like, are you crazy? And he's like, no, I'm not. I'm bringing it where it's supposed to be brought. Good luck saying that person is, weaponizing.
Yeah, this is in some way corruptly persecuting the innocent president who just happened to keep a few dozen boxes of highly classified documents.
So question for you, Rick,
Sure.
is, so now people can see at least a snippet of himself and get a
Yeah.
sense of him. And the Republicans had sought a voluntary interview, but not a public one.
Right.
And Jack Smith's lawyers said, happy to do it, but it's going to be public if you want him to come. I'm going to be interested to see whether the Republicans give him that forum,
I gotta tell
because
you, I think
it's
there's
dangerous.
I think there's a 0% chance they let Jack Smith walk into that room with a chapter and verse recitation of the things that are in those filings, of the documents that were there, of the retention practices that were that were there, of the attempted cover up. That I think Todd Blanche is going to call Donald Trump, and he's going to say, "Boss, if you let Mike Johnson do this, we are putting ourselves in for a world of hurt, politically and optically, and maybe down the road legally." I think this is a bridge too far, and it's pretty evident. You watch that interview, and you know Jack Smith's reputation. James Comer is a 2-watt light bulb compared to the spotlight that is Jack Smith. I don't think they have the intellectual horsepower on that committee or any of the Republican-led committees in the House to invert Jack Smith into the villain here. I think it's real hard for them to get to that point.
Yeah, I mean, I don't know why they would risk it, because I think
stupid.
he's going to come off extremely well. And to me, I'm not a political analyst, but it's like, to me, it's better to just continue vilifying him, but don't give him a platform. And I thought it was just wonderful for him to speak,
It
because
was a great interview, and you did.
well, no.
Yeah.
It's not about the interview, and it's not about me. It is that I think it's
No,
just
but
so useful to hear him, and so that you can actually make a judgment about him and not a caricature of him.
Right, and, they use the whole, like, Jack Smith with a big full beard and wearing that European court robe as a sort of like, "Look, this is a guy from an alien spaceship here to
Right.
go attack Donald Trump."
From Star Trek,
Right,
right?
exactly. And now, you see this guy who is confident in the propriety of all the steps he took during this case, which is why he doesn't play the role that they want him to play as a patsy in a hearing like that, which is why I think that's a low probability. And I also think if it gets to court, I don't think Jack Smith is gonna be a guy who's gonna, walk in the door like some dewy-eyed schoolgirl and, like, panic over their assertions.
So let me just focus on that for a second. If you think about the cases that have been brought, Letitia James,
Right.
James Comey, even John Bolton, although, as I said, I
Again,
think
Bolton
Bolton's
said about
different. Yeah. But all three are not about the Mar-a-Lago classified documents case. They're not about January 6th.
Right.
They're not, those are you have to, if you notice, they're finding stuff that's like marginal, off to the side, which doesn't open the door, they think, to Donald Trump's wrongdoing.
Mhm.
If you're going to indict people for things involving investigations of Donald Trump wrongdoing, you open the door to the trials that Donald Trump spent years
Avoiding.
trying to avoid.
Yep. I think that's
So
exactly right.
when he said, I think we should indict Liz Cheney, I'm sure she's not thinking, oh, great, I can't wait for that to happen. But I thought that's never going to happen, because really, you want to have a trial on
You
the
wanna
January
open up
6th
all that
case?
January 6th material they didn't release? Sure, Donald. Let's do that. That's an exciting trip down memory lane. Well, Andrew Weissmann, I appreciate you as always, my friend. This is an ongoing through line, I think, of this administration that we have to keep our eyes on in the coming months, because this abuse of judicial power is they projected it for years, and now they're the ones involved in this weaponization and this abuse of power. So, Andrew Weissmann, thank you so much for coming on the Lincoln Project podcast, as always.
Thank you so much.
Good night and good luck.